And then our second amicus brief is on the individual mandate. Now, some people say that forcing someone who doesn't have health insurance of the particular style mandated by Congress and who doesn't want to buy it, somehow that's a regulation of commerce among the several states, as the Constitution says. And I think that's an implausible argument that forcing someone to buy something he doesn't want is somehow regulating commerce. So then the question becomes, well, if it's not a regulation of commerce directly, could you say it is, under the Constitution, necessary and proper to regulating commerce? And in a way, just in the broadest dictionary meaning of necessary, you could say yes, because this whole thing of saying health insurance companies must take customers and price those customers at levels that have nothing to do with the genuine actuarial risk of a particular customer. Of course, that will never work to, in essence, force insurance companies to sell insurance for far below the true actuarial cost to some people, unless you can force other people to buy insurance at vastly more than their true actuarial cost. So is it necessary in that sense? Yes. But what we explain in our Independence Institute amicus brief is that when the Constitution was written, and when the necessary and proper clause was interpreted in what remains the decisive case about that, decided by Chief Justice Marshall and a unanimous court in 1819, McCulloch versus Maryland, that the phrase necessary and proper is a legal term of art, well understood at the time. And one of the principles of the necessary and proper clause is that when you imply a power, an implicit power from a enumerated power, that implicit power, among other things, must be less worthy in the phrase of the time, or inferior, also in the phrase of the time. This incidental power must be less than the enumerated power from which you were implying. So, for example, if I said, well, I'm leaving the country for 5 years, so I hire you to manage my farm, and I grant you all the powers which are necessary and proper to manage the farm. Well, can you tear down the fence and put up another one because you think that's would be better, could make the fence work better? For sure. Can you change the crop from wheat to sorghum? You bet. Can you repaint the barn? Yes, all those things are necessary and proper to managing the farm. But now suppose somebody comes along and offers to buy the farm for what seems like a good price. You think, oh, wow, that'd be a good deal for Kopel. He's paying 50% more than the farm is worth. So on his behalf, can I sell the farm? And the answer is no, because the power to sell the farm is not an inferior, incidental, less worthy power than the power to manage the farm. The power to sell the farm is as great as, at least as great as, the power to manage the farm. So if I'd meant to give you the authority to sell the farm, I would have said, Ari has the power also to sell the farm. And how this comes into the Obamacare individual mandate is when in the Constitution the people granted to Congress the power to regulate commerce among the several states, they also granted to Congress incidental powers along with that, those inferior, less worthy powers. But they didn't grant to the Congress the power to compel commerce, to force unwilling people to engage in commerce. Because when you compare the power to regulate existing voluntary commerce and the power to force unwilling people to engage in commerce, that latter power is not an inferior incident. It is at least as great as, indeed it is far superior to, the power to regulate voluntary interstate commerce. And so the power to force people to buy health insurance they don't want cannot possibly be necessary and proper to the legitimate constitutional power to regulate commerce among the several states. And we think there is a good possibility that the case may come down to exactly this point, and we're hoping that by explicating to the Supreme Court, justices and their clerks, the original meaning and the correct understanding of Chief Justice Marshall's great opinion in McCulloch versus Maryland, we may preserve the constitutional structure of the United States, which is the federal government has many important powers which should be exercised to their fullest, but it is not a government of unlimited powers. The people granted to Congress and the United States government as a whole many important powers, but they did not grant to Congress everything. And the power to compel Congress, the power to compel commerce, was not one of the powers that was ever, by direct statement and enumeration or by implication, ever granted to the Congress of the United States.